Morning, everyone. We are going to get started our WebEx webinar dealing with operator and non-operator disputes in the uncertain economic times that we are faced with. So I'm get started. I want to thank everybody for joining us. I can tell you that we have over 165 registrants for this seminar. So we have a very good cross-section of participants, both on the operator and non-operator side. And we're here today to have a discussion on the issues that may arise between operators and non-operators during these times. Obviously, this is not legal advice for any particular situation. If you have something that you need to discuss, you should, of course, get appropriate legal counsel to deal with your particular situation. This is a discussion at a reasonably high level to whet people's appetite and talk about some of the issues. So my name is Mike Marion. I'm going to be the moderator of today. I'm a disputes lawyer at ELG. I'm the regional group manager of the commercial litigation group in the disputes group. I'm also the co-leader of our appellate advocacy group in Calgary. Oil and gas disputes are a large part of my practice. I have here, and I'm very thankful to have with me today, 3 panelists from our firm. First of all, Clay Jacobson is a partner in our disputes practice in commercial litigation. Clay has significant experience also in oil and gas and energy disputes and advising those clients through disputes situations. Clay also has significant experience dealing with matters of fraud and collections. I'd like to also introduce Xiaodi Chen. Xiaodi is a partner in our Calgary office as well, but Xiaodi is a partner in our securities and capital markets group. He has significant mergers and acquisitions and corporate finance experience, and the reason we wanted him on this panel in particular was he has significant experience advising energy clients and has a number of energy clients. I'm sure some of them are on the phone or on this call. Xiaodi will bring the non-disputes or practical commercial perspective to our discussion. And last but not least, we have Maddie Lemons, another partner in our disputes and commercial litigation group, also with significant experience in energy disputes. Maddie also brings particular experience from the insolvency side and is our regional leader of our national environmental group, so has that experience as well. I'm going to just start by commenting on the situation that everybody's well aware of, and you know, the folks on the phone know how this situation is affecting their business better than we do. But obviously, the COVID pandemic has decreased demand for energy. It's depressed economies. You couple that with the OPEC price war and oversupply, storage issues, has all led to depressed commodity prices, which is mildly. And that's, in turn, we are well aware, is putting enormous economic strain on the oil and gas industry participants, which, from our experience in past times, of course, none as bad as this, perhaps, that's a recipe for disputes between operators and non-operators. On this slide, we sort of highlight the main areas that we're going to cover in this discussion. We will be using a sort of question and answer format. We expect we'll run 45 to 50 minutes going through these questions. We will hopefully have time for some questions that were posed before by some of you that are attending this call, and hopefully we'll address a lot of those questions in our discussion. People are muted to make sure that this runs smoothly, but we encourage you to use the chat feature, which you can access with the little blue message button on your main screen. You can use the chat and ask us additional questions that may come up, and if we have time at the end, we will try to address those. So we will talk about the nature of the relationship. We will talk about the remedies against defaulting operators. So from the operator's perspective, we'll discuss the flip side of that, remedies against defaulting operators, and then we'll have a discussion about some of the issues that arise when operators and joint interest owners are considering shutting in production. And with that, we will get started, and I will have the first question for Jody. We'll start with you. Maybe you can provide some background and insight into the source of the potential disputes or struggles, and comment on the nature of the operator and non-operator relationship. Jody?
Hi, Mike. Yes, for sure. Thanks for that introduction. So at the heart of the operator and non-operator dispute is the question of what is the fundamental relationship between the operator and the non-operator. And this has been a difficult and evolving issue from the beginning that the capital documents and the courts have tried to grapple with. On one end, working interest partners are industry competitors, but on the other hand, they are working together, jointly owning, cooperating on operations and development for these joint interests. Their situation and their interests outside of the joint interests will differ, and so as a result of that, which decisions maximize their respective benefits under these joint interests will also differ. So the way the operating procedure has tried to deal with this inherent conflict between the parties is to specifically prescribe certain duties and obligations and set out certain procedures for situations that happen often enough, and then provide some general statements and guidance to help the parties figure out and interpret what their other obligations are and what they should do in those situations. This guidance and these procedures evolved based on issues and disputes that arose between the parties at the time, and as we head into this new industry landscape, as Mike has described, we are going to be seeing completely new areas of conflict, or we're going to see different areas of conflict becoming more prominent, and different contentions arising between operators and non-operators. Back in the day with $80 oil, the main disagreement between operators and non-operators was frequently over whether or not to spend capital and drill that incremental well. And the solution that everyone came up with was to pre-agree on a procedure to allow non-operators, if they disagreed, to take on independent operations and deal with the economic equities here by penalizing non-participating working interest partners. And successive capital procedures have refined these and brought it up to current drilling techniques. But today, the divergence or the conflict is more likely to arise from different issues, two different issues that we think of. One is solvency concerns and I guess the exposure between the parties with these joint interests. And second, how to best manage production of existing reserves during low commodity price environments where different working interest partners have different economic results from producing or not producing. For example, an operator's decision or a non-operator's desire to continue to produce at really low prices is swayed by many factors, including their current liquidity situation, their mindsets, whether they are short-term or longer-term, their infrastructure position, i.e. whether they own the processing plant for the production, and all of these differ. A cash-strapped producer that is looking to survive, get the next dollar, and fight another day might want to produce the reserves no matter what, while a producer with liquidity and a longer-term outlook might want to hold off if you're producing reserves at below their F&D costs. On the solvency side, the question is how do we fairly deal with exposures on agreements that may be held by operators for the benefit of all working interest partners, and sometimes these are large commitments. How do we fairly split these financial risks and rewards when some of these partners may go out of business and leave the operator exposed to the underlying liability on its own? So I think a lot of these issues that we're coming up to today and we'll be looking at tomorrow will be different from what we've considered in the past, and they haven't been thought through in great detail yet. And we're going to be spending a good deal of time looking at our existing remedies and seeing how they can apply to these new situations, as well as coming up with new tools to fairly balance these competing interests.
Okay, thanks, Jody. And with that, I think I'll move on to Clay and ask you, Clay, to address the issues that operators will face in this environment, and what are some of the remedies that they should be having top of mind for dealing with delinquent non-operators.
Thanks very much, Mike, and thanks for that introduction, and thank you to all for attending this morning. Two of the key issues that we're seeing arise for operators are number one, disputes arising from non-operators that are failing to put up their share of prepaid expenses. And number two, concerns over shutting in wells or facilities where the non-operator either hasn't been consulted or the non-operator doesn't agree with shutting in. We'll focus later in the presentation on shut-ins, but first I'd like to address the remedies that are available to operators in the event they're dealing with a non-operator that has failed to or is threatening to fail to put up their share of expenses incurred by the operator, or in other words, the JIB account is in a deficit position and is not being remedied. The operator has a number of remedies available under the various capital operating procedures where the non-operator is in a default position. In the most recent capital operating procedures, 2015 and 2007, these are found at Article 5.5, and in older versions, they're at Article 505. There are numerous remedies provided, including the right to charge compound interest on outstanding amounts, the right to withhold information and rights while in default, with some exceptions. There is a contractual right to sue for the unpaid amount as a debt due and owing, but that may be of little value if the defaulting party is in significant financial distress and cannot immediately satisfy a judgment. So there are three remedies that are likely most effective and that I'd like to focus on here, which are displayed on the slide. They are the operator's lien, the right of set-off, and the right to treat the default as an immediate assignment of all proceeds from production. The operator's lien is an important option because it gives the operator a right of recourse directly against the defaulting party's interest in the joint lands and all the wells and equipment, which can be sold to recover the amount in default plus interest. The prospect of losing its interest in the joint lands will certainly motivate otherwise reluctant parties to deliver their proportionate share of expenses if they're able to do so. And so delivery of the mandatory 60-day notice will often spur payment. If the defaulting party is not in a position to deliver funds, the operator will be in a position to enforce its lien against the lands and equipment, dispose of it for a reasonable price, and apply the proceeds against amounts owing. From a practical perspective, this requires an application to the court to properly enforce. The capital operating procedure makes reference to any required court order in enforcing an operator's lien, which suggests that the process could potentially be done without a court order. But realistically, an operator engaging in this process will want to obtain a court order to obtain a judicial determination confirming the operator's right to sell the defaulting non-operator's interest, and to provide assurance to the purchaser that it is acquiring the non-operator's interest free of any adverse claims or prior security, and also to ensure that the registrar at Land Titles has the required direction to transfer the interest. The capital operating procedure creates a lien against the non-operator's interest effective at the time of the agreement. It's not the time of the default. And so if there's another secured creditor claiming priority, the critical issue will be the time the competing security was granted. If there's Bank Act security granted after the date of the operating agreement, you'll have a strong argument that your operator's lien has priority. But conversely, if there is security granted prior to the operating agreement, you'll likely find that your lien is subordinate to the prior security. If you're an operator considering the operator's lien remedy, you'll want to issue your 60-day notice as soon as possible. Consult with counsel well within that 60 days so that they can prepare your materials to obtain the order permitting you to take possession and sell the defaulting non-operator's working interest at the first opportunity. The two other remedies to note in particular are the right of set-off and the right to take an assignment of the proceeds from production. The right of set-off enables the operator to apply amounts owing by the defaulting non-operator against under any agreement. It need not be amounts owing under the operating agreement in question. So if you have other business with the defaulting party, as an operator, you can apply amounts otherwise payable to that party against its unpaid expenses for operations. And notably, there's no corresponding right of set-off by the defaulting party, so it's not an overall balancing procedure. For non-operators' unpaid expenses, you're entitled to set off against amounts owing to you by the non-operator without accounting for any amounts that you may be owing under other business arrangements. I would note that the specific contractual right to set off is not contained in the CAPL versions prior to 1990. So if you're dealing with operations governed by a 1981 CAPL or earlier, you'll want to consult with counsel about the prospects of exercising a common law or equitable set-off right because the contractual set-off is not provided. Also, if the defaulting party is insolvent or on the brink of insolvency, you'll want to be careful about exercising your right of set-off. A court may ultimately find that exercising your set-off right constituted an unfair preference to the detriment of other creditors and require you to repay those funds to the trustee or receiver so they can form part of the distribution to creditors. That can be an expensive legal exercise that nullifies any potential benefit of the original set-off, and it's a risk to be aware of. Obviously, the self-help remedies are there to ensure that the operator is kept whole with respect to expenses incurred on behalf of other participants. But if you have every reason to believe that your joint interest participant is on the eve of insolvency, you'll want to weigh the benefit of having a bird in hand against the prospect of litigation down the road. Many operators consider the bird in hand to be optimal and elect to deal with and resolve competing claims if and when they arise, but it's something to be aware of if your counterparty is exhibiting significant signs of financial distress. Finally, and perhaps the most common and effective self-help remedy is the assignment of proceeds from production. When a joint owner fails to deliver its share of expenses, the operator is entitled to an immediate assignment of that party's production proceeds, which can be applied against the debt owing for prepaid expenses. So if there's a positive balance in the JIB account, the production proceeds can be applied by the operator against the balance owing. Like the set-off remedy, the assignment remedy also requires 30 days notice before it's implemented. And so it's prudent to issue such notices immediately upon default by the non-operator. And again, where there's reason to believe that the defaulting party is on the eve of insolvency, you'll want to be cautious about helping yourself to production proceeds out of the concern of claims by other creditors of an improper preference, just as you consider that with the set-off remedy. So again, there are a number of remedies available to operators. The ones to be top of mind in this context are the operator's lien, the set-off right, and the assignment of production proceeds.
Okay, thank you, Clay. Now let's sort of flip the discussion and reverse it. And Maddie, I think if you could please comment on the remedies that non-operators may have or wish to consider against operators who may be in default of their obligations. Over to you, Maddie.
Sorry, you know what?
Maddie,
I was on mute. So thank you for that, Mike. So on the flip side from Clay's discussion, of course, there's going to be many non-working interest owners that are likely to find themselves also needing to take action in these times, given the heightened financial stress that the industry is under right now, and really concerns about the financial viability of operators. And so non-operators can look at claims for compensation, or they can also look at, they might have a desire to replace the operator. So there are at least 3 instances in which a non-operator may have a claim for compensation against an operator. One is where an operator has not distributed the entire proceeds from an asset to the non-operator. 2 is where funds were prepaid, let's say under an AFE, and those funds were not actually spent on their intended use. So those funds should be returned to the non-operator rather than being used for something else. And the 3rd is where an operator has shut in the well, and that shut-in results in the termination of the lease. So in the context of an insolvent operator, those claims all become a little bit more complicated. Claims for cash advances and production proceeds are, of course, trust funds, so they don't actually form part of the estate of the operator in an insolvency, and thus do not form part of the funds that other creditors can claim against. But if the trust funds are commingled or dissipated, it's not so simple, and there may need to be a tracing of those funds. So if a non-operator wants to make a claim against trust funds, it should do so as soon as possible, hopefully before any dissipation occurs. But if the trust funds have been transferred elsewhere already, then claims should be made against the directors and officers of the operator under the doctrine of knowing assistance, or you may want to investigate whether claims can be made against third parties for knowing receipt. So in considering a claim against directors and officers of the operator, generally speaking, one has to prove that those directors and officers took a risk, prejudice of the non-operator, such that they were reckless or willfully blind in doing that, and thereby assisted in defrauding the non-operator. So that may be established by proving that they knowingly commingled funds, for instance, allowing those funds to be spent on other assets or to the benefit of other parties. So it's unlikely, given that there are elements of fraud in a knowing assistance claim, that any sort of director and insurance policies would cover those types of claims. If you're on the operator side, you might want to check your policy to see what specific coverage you have for directors and officers for those types of claims. But on the non-operator side, just be mindful that chances are D&O insurance isn't going to cover your claim on that. So the only reason that you should be looking at director and officer claims is if you have a very high likelihood of success on those claims and you think that there's actually some recovery there against those particular individuals. So in considering a claim for knowing receipt against third parties, which could include the directors and officers if they are the ultimate recipients of those funds, but one must prove that the third party received the trust funds from the operator, that there was a breach of trust, that the third party actually knew that they were trust funds, and that the third party took and used the money for their purposes in any event. So non-operators must be vigilant to watch the trust funds they have with the operator. You should be watching regular statements of account and making sure that you are receiving those statements of account on proceeds from production and on AFEs to see where the money is going and being spent. And you may be able to obtain recovery against other service providers or creditors if they actually receive your trust funds from the operator. There are also fiduciary duties to consider. So fiduciary duties are found where a party is supposed to be acting in the best interests of another party, usually where that party is in the care and custody of property for another party. So obviously, in our context of operators and non-operators, we've got a party that is caring for the asset for the benefit of the non-operators. However, the 2007 and 2015 versions of CAPL specifically provide protections for operators. So there's actually provisions that state against a finding of fiduciary obligations for operators. Fiduciary duties were not expressly addressed in the 74, 81, and 1990 versions, but these later versions explicitly state in clause 1.05a, for instance, in the 2007 version, that there is no fiduciary duty from the operator to the non-operator except for 3 specific duties relating to 1, commingling of trust funds, 2, distribution of proceeds, and 3, confidential information. So these limits on fiduciary duties haven't really been fully tested in the courts, though, and CAPL even recognizes that a broader scope of fiduciary duty might ultimately rise and be upheld by the courts, because CAPL is really just a contract, and of course tort duties can arise beyond the 4 corners of the contract. A finding of a fiduciary duty on a non-operator could result in judgment for damages or an order to disgorge any benefits obtained by the operator through that breach of its fiduciary duties. So that could result in something like a constructive trust over any property that the operator purchased using those trust funds, for instance, such as the non-operator's portion of the proceeds from production or the prepaid expenses funds. If those are used to purchase something else by the operator, then there could be a constructive trust claim against that particular property. There is also the ability to replace the operator, so that can be automatic upon certain conditions. So in the 2015 CAPL, for instance, in clause 2.02, those automatic replacement rights, they arise when there's an insolvency of the operator, there's shareholder proceedings to wind up the operator, judgment against the operator is registered against the working interest and it remains unsatisfied for 30 days. There's a default under the title documents, and I know Clay's going to speak to shutting in issues in a moment here. If there's a default under the regulations, or the operator assigns its duties to a party that is not an affiliate. There are also other ways in which the operator can be challenged or voted out, so not automatic. And those are also found in clause 2 of the 2017 and 2015 CAPLs. So this is a good remedy for a non-operator when it appears economic to take over operatorship and the trust has broken down between the parties, such that the non-operator no longer trusts the operator, and the non-operator is going to do that and take on an operator role. It certainly needs to ensure that it actually has the wherewithal to do that. So it has the resources, both financially and practically speaking, to take on an operator role. During this time, of course, we see that people are having to consider layoffs and that sort of thing. And certainly we're going to have less staff available to handle all of our health, safety, and environmental obligations. And so just speaking from a non-operator perspective, you really want to make sure that you consider your environmental investigation and audit rights in this particular crisis. So those are found in clause 3.05 of the 2007 and 2015 version of CAPL. And you can use those audit and investigation rights to confirm that regulatory obligations are actually being met. So in terms of health, safety, and environment. And this type of inquiry can also provide further insight into an operator's fulfillment of its obligations more generally. Of course, a non-operator can become liable at common law or under the regulations for breaches of those types of obligations, especially if the non-operator actually knows about a breach. So if you've conducted such an inquiry and you find out about something, you have an obligation to ensure that the regulations are being met. You just need to be mindful of those types of issues as well.
Maddie, before we move on, can you mentioned change of operatorship, and can you expand on that a little bit in the context where there may be an insolvency involved?
Yes, of course. So when it does come to insolvency, there have been some mixed results in the courts in Alberta about how automatic the replacement right is to replace the operator. And so it is certainly clear now from a series of cases that the stay of proceedings that's part of the insolvency will need to be lifted. And that really depends upon the facts of each case. So for instance, in 2016, we had the bumper development case in Alberta. And in that particular case, Eagle Energy, who had a non-operating interest, immediately gave notice that it wished to take over operatorship and also put a bid in to buy the assets, indicating that if it was not successful in that bid, that it at least still expected to take over the operatorship. And ultimately, Eagle was not the successful bidder on those assets. Another third party, Forent Energy, was. And when the receiver went to approve the sale investing order to transfer the assets to Forent, Eagle asserted its right to operatorship again and was in fact successful, in large part due to the fact that it had asserted its desire to replace the operator very early on in the process. And so the receiver had marketed the assets as being subject to Eagle's right of operatorship. So the court lifted the receivership stay to permit Eagle to replace the operatorship in accordance with its capital rights. That had differed from an earlier case in Alberta back in 1988 involving Norson Energy, which did not actually allow the enforcement of the right to replace the operator in the context of a CCAA restructuring, because in that particular case, it was seen as part and parcel with the restructuring effort that the party would be able to continue the operatorship. Then we had the case of Lexon Resources in 2019, where Justice Romaine of our Queen's Bench distinguished the facts in the Lexon case from this bumper development case, because in the Lexon case, the non-working interest had actually been purchased by Midstream during the receivership process. And so already after the receiver was appointed, that Midstream purchased the assets and then asked to take over the operatorship. And so the court was quite reticent to permit any sort of opportunistic attempts to take over operatorship by purchasing non-working interests during a insolvency process, because the receiver was also already well into marketing the assets in that particular matter. And so it had actually marketed the assets as including the right to operatorship. So as if the operatorship was an asset part and parcel with the actual physical assets that had been held by Lexon. And so the court actually declined to lift the stay in the Lexon case to enable Midstream to take over the operatorship. And the court noted that the concerns that a non-operator might have, typically arising under the capital, about dissipation of funds by an insolvent operator, were not real concerns in this particular scenario, because the operator role had already been taken over by the receiver, who's an officer of the court. So there's not really any risk of dissipation of those funds. So, bottom line is each case of replacing the operator will be examined on its individual facts. If an operator goes insolvent while you own a non-working interest and you wish to replace the operator, it's important to let that desire be known as early as possible. And if you can, try to insist that the receiver not market the operatorship with the assets. But again, it's unlikely that if you buy a non-working interest in assets operated by an operator that has ultimately gone into insolvency proceedings, that you're going to be able to opportunistically take over operatorship. So you'll just need to keep that in mind.
Okay, thanks. Jody, any practical perspectives on this operatorship issue?
Yeah. Just to add a little bit of color, these operators going insolvent is something we're seeing more and more of. And as Maddie mentioned, there is a whole slew of new case law on this, including the bumper and the Lexon case. From a commercial perspective, I think the base position to think about is receivers really don't want to give up operatorship. Operatorship gives them the ability to continue to collect the revenue, which is very helpful in running the receivership. And so while Maddie says it is possible and precedented to go to court and get a stay, the stay lifted and exercise this limited remedy to replace the operator, this is really a time-consuming and costly procedure, and depending on the circumstances, sometimes not successful. So what we normally see is that non-operators decide not to challenge the stay and just allow the receiver to continue to operate while the stay is in effect. But what they would do is, as Maddie says, as early as possible, put the receiver on notice that they intend to exercise their remedies. And sometimes we've seen non-operators go out and try to inform third parties that, hey, we have an interest here and we would like to take over operatorship afterward. Just so everyone is aware that this is something that is at dispute. And it now is commercially what happens in receivership cases, receivership offerings that no receiver will guarantee that the operatorship will transfer over. There's always that caveat in the receiver PSAs to say we'll do what we can, but we can't guarantee the transfer of operatorship.
Okay, thank you very much, Shouty. We'll move on to the last topic that we were going to cover before we address any questions, and that's the issue of shutting in production. And Clay, maybe you can address the issues that joint owners, both operators and non-operators, should have in mind when they're considering shutting in production in this environment.
Thanks, Mike. Happy to do so. First of all, under the capital operating procedures, there is no express provision requiring the operator to obtain the approval of non-operators prior to shutting in a well or facility, unless the cost to do so meets the threshold of requiring an AFE. With that said, though, the operator is delegated the management of the joint operations and is required to consult with the parties periodically about the development and operation of the joint lands. An operator has an obligation to conduct operations in a good and workmanlike manner and in accordance with good oil field practices, and to maintain title documents. If it doesn't do so, the non-operators may seek to replace the operator, as Maddie and Shouty have discussed, and it may also face liability to non-operators. And in that respect, one key consideration is whether shutting in will result in termination of the underlying leases and potential liability to non-operators. Generally speaking, an operator is only liable to non-operators for matters related to operations, including permitting leases to terminate, if the operator is held to have engaged in acts of gross negligence or willful misconduct. In other words, there must be a more significant departure from the standard of a prudent operator than in the case of ordinary negligence. But that said, there have been cases where the operator's conduct in permitting a lease to terminate due to a shut-in has been found to constitute gross negligence or willful misconduct. Of course, that was a finding within the confine of the particular cases, but all should be aware that certainly it is a possibility. Whether a lease will terminate as a result of a shut-in will depend on the specific terms of the lease, of course. And of course, there are many different forms, and so it's therefore necessary when contemplating a shut-in to review the underlying leases in advance. Many leases contain a shut-in provision that stipulates that the lease will continue insofar as there's a shut-in well capable of producing the lease substances. And this has been interpreted by the courts as meaning capable of producing in meaningful quantities, or in other words, it's commercially viable to continue production. The lease may be held to terminate if the well remains shut in after production has become economical and profitable from the perspective of a prudent lessee. And so it's incumbent upon an operator contemplating a shut-in to examine each impacted lease to determine whether the shut-in is permitted and in what circumstances, and to resume production once it becomes viable to do so, failing which the lease may ultimately terminate. If the shut-in does result in termination of the lease, the operator may be liable to other joint interest owners. That liability can, of course, be mitigated significantly by consulting with non-operators in advance so that they have an opportunity to participate in the decision to suspend the well. Under the capital operating procedures, an action that was approved by the other joint owners cannot meet the definition of gross negligence or willful misconduct. So although there's no specific express provision in the capitals that require consultation with non-operators, there is good reason to do so, and I know that several of our clients have elected to consult with their non-operators prior to shutting in. Furthermore, in light of the COVID pandemic, another possible answer to a claim by a non-operator for permitting a lease to terminate is to assert that an event of force majeure has occurred. The capital operating procedures and most leases contain a clause that suspends the party's obligations in the event that they are prevented from performing them due to an event of force majeure, which there are different definitions of force majeure, but essentially it involves an act of God or an event that is beyond the control of the parties, which prevents them from performing their obligations. It should be noted that under the capital operating procedures, the definition of force majeure does not absolve parties from their responsibility to make payments, and also the definition of force majeure expressly excludes lack of finances, and in fact the 07 and 2015 versions also exclude changes in parties' economic circumstances and changes that affect the economic attributes of investments. And so those reasons alone do not constitute an event of force majeure. A party claiming force majeure is required to promptly notify the other parties of the nature of the force majeure event, the suspended obligations, and the anticipated duration of the suspension. And so operators citing the COVID pandemic in the event of as an event of force majeure will want to consider listing items other than the effect of COVID-19 on current oil prices in their force majeure notices. So labor shortages, governmental orders requiring social distances that preclude the continuous operation and the like are items to consider including in the force majeure notices. Citing only economic or purely financial factors in your notice to non-operators of the suspension of obligations due to force majeure runs the risk that your cited reasons do not in fact constitute a force majeure event under the CAPL. It should of course be kept in mind that the purpose for shut-in provisions is to protect the lessee from the termination of the lease due to lack of production, where the wells are capable of producing in paying quantities, but where there is no market for such production. So to recap, when shutting in a well, certainly the lack of a viable market for produced substances should be cited for the purpose of relying on the shut-in provisions. And if you're also asserting an event of force majeure, you'll want to consider including additional factors such as the practical challenges that are created by the social distancing orders currently in place. Keep in mind that if the lessor purports to terminate the lease due to a lack of production, it'll be the operator that has the onus to prove that the shut-in requirements in the lease were in fact met or the force majeure provisions were properly triggered. So with that, I'd like to turn it over to my partner, Zhaodi Jin, to provide some additional practical considerations from a commercial perspective that come into play with respect to shut-ins.
Thanks, Clay. I think this question of shutting in is really timely right now. We know of quite a few companies that have shut-in production. And just yesterday, I've been reading news releases of companies announcing they're shutting in, and one news release of a company announcing that their working interest partner has shut in their production. And as Clay outlined, I think that if there's a technical or operating reason or something that you can specifically pin to in the procedure or in your specific rights and duties as operator, that would be the best way to hang your hat on and make a decision. But if there are no technical or operating reasons here to make this decision, and it ends up being a purely economic type of decision and based on the operator's general duties, the question is, how do you proceed then? Well, the easiest way is if you can get consensus. If all of your working interest partners say, yep, the price is too low, this is what we should do, we should shut in, that would be great. But without consensus, I think we would have to look at the operating procedure as a whole and think about what the obligation and duties are. And there is some guidance. So the operator must operate in a good workmanlike manner, observe prudent reservoir management and conservation principles, and operate for the collective benefit of all parties. There's also some concepts in there about producing commercial quantities or paying quantities that might help guide us. Those definitions are tied to drilling decisions, but the way that they are framed and how those decisions are thought through in the procedure, I think give us a little bit of guidance on how to think through these type of economic issues. So once you're in this situation, I think you have to very carefully consider what your duty is and remember that fundamentally, as operator, you're operating for the benefit of all working interest partners and not for your own benefit or to the detriment of any of your partners. So it might be hard for an operator without any technical reasons and without consensus to, for example, produce a negative cash flow field in order just to fill their processing plant income without any other reasons. But I think the situations that we are going to be facing and seeing in today's economic and operational environment is more complicated fact patterns where the different working interest parties' hedging positions, their existing transportation commitments, their infrastructure positions, their immediate liquidity demands, and all these other factors make it difficult for there to be one clear answer for the operator and make it very difficult for the operator to actually get consensus. So I think for these types of situations, it's best maybe to talk to your counsel and walk through what are the risks and benefits here. Another thing that Clay mentioned that I thought was very interesting is the standard of care for this type of a decision, as Clay mentioned, and I agree, the procedure sets out a gross negligence standard here, but it seems to me that with the open-endedness of the capital procedure and the complexity of these issues, maybe that's and the controversy around these decisions, maybe this is not something you want to just rely on or test, and you want to think through a bit more clearly before making these types of decisions.
Thank you very much, Clay and Jody, on that point. And just listening to you, it really does illustrate that this shutting in issue is a bit of a minefield. The consequences can be very high on the parties that are making those decisions or the parties that are feeling the effect of that decision. And you know, there's the two layers that you guys have described. One is the operating agreement layer, and what are the provisions of that? When can force majeure or other factors be relied on? But then there's the whole additional layer that everybody needs to be considering, which is the vastly different lease terms that allow for shutting in. So there's multiple layers that need to be looked at. And I just wanted to add a comment, which we haven't touched on and won't because it can overwhelm any presentation, but that's the duty of honest performance. And there is obviously Supreme Court of Canada case law confirming the duty to act honestly, not mislead your counterparties. So obviously in any of these situations, parties would be well advised not to be infringing that. But even more than that, there's a recent case from February of this year, which I'm happy to speak to anyone about because I was involved in it, where the court has made a statement about the duty of honest performance and, in my view, extended it a little bit to say that that duty of honest performance actually includes an obligation to make a good faith effort to perform the contract, which is a little bit different than just not deceiving your partners or being dishonest with your partners. I could very much see that kind of concept coming into play on decisions to shut in when you don't properly consider the impact that might have on the legitimate contractual expectations of your counterparties. So I just thought I'd throw that bomb into the minefield. That really covers the main part of our presentation. But we did want to, since we have some time, we did want to address a couple of questions that were put to us before as people registered. And the first one I think Maddie is going to address, and someone asked Maddie, what are the best practices for non-operators upon observing indicators of the operator's strained financial viability?
Thanks, Mike. So, yeah, I mean, as I said before, it's always important to be vigilant. You know, as the non-operator, you're not in the driver's seat, so you need to be asked to be kept informed by the operator. And during a time like this, in this COVID crisis and the oil prices, you really need to ask to be informed in real time. So, you know, as a best practice, it's also best to insist that the operator keep separate trust accounts if you can. I know it can be cumbersome for those operators to do that, but in times like these, it's just too easy that trust funds can be dissipated and just disappear. And a non-working interest owner of that owns 60% or more can actually give notice to the operator to not commingle funds under the 2007 and 2015 capitals. So, you know, if there's a real concern over financial viability of the operator, it's probably prudent to issue that type of notice to not commingle funds so that you don't end up in a scenario where you're having to trace funds and see if there's anything left. You know, as I mentioned earlier as well, I think we need to ensure that any claims are asserted as early as possible. So don't let it carry on for any length of time. You know, you really want to let everyone know that you're seeking compensation, and you're going to do that by getting your statements of account regularly and seeing what's going on. Or if you don't trust your operator because they're not providing statements of account, then you might want to look at replacing the operator. But with each of those, you just want to make sure that everybody knows that early. You know, when we were talking about the insolvency context, for instance, you want to make sure that you tell everybody and give notice to the receiver or to the party that you think might go insolvent right away that you are desiring to take over the operatorship, because as we discussed, it might not be possible if the operatorship is then marketed with the assets by the receiver or something like that. So you really just need to make sure you give notice early. And if your relationship has broken down with the operator, you know, now's the time to replace the operator. Don't let them carry on. You know, it's not a good business relationship to have where you don't trust your counterparty that's actually in the care, custody, and control of your assets. So you should assert that right to replace the operator as soon as possible.
Okay, thank you, Maddie. We have time for one more of the questions that was asked of us as part of the registration process. And we chose this question because it's particularly appropriate right now when we are in the situation where the courts have really limited what they're doing to emergency and urgent matters. And the question was this, and Clay is going to address it. The question was, how effective are capital operating procedures in resolving disputes? Have parties had to resort to mediation, litigation, or arbitration? And of these, is anyone preferred and why? Over to you, Clay.
Thanks, Mike. And yes, it is a very important and timely question. The dispute resolution mechanisms outlined in the capital operating procedures have evolved over the years. The 1990 capital placed no restrictions on the parties' ability to commence court actions against one another, although the annotations promote consideration of mediation or arbitration. The 2007 capital introduced a dispute resolution provision, which is also in the 2015 capital, whereby certain listed disputes must be dealt with through binding arbitration. There's an elective provision that, if selected, calls for good faith negotiation of those disputes listed for arbitration. And those negotiations are to take place amongst designated representatives and on a set timeline. And there's an ability of either party during those negotiations to refer the matter to mediation. So parties conducting operation under the later capitals will want to review the types of disputes listed in Article 21 to confirm whether they're required to negotiate, mediate, and arbitrate. If not, then the dispute may be litigated in the courts. But regardless of whether there's a binding dispute resolution provision, the most prevalent method of resolving disputes under the CAPL is through direct negotiation. Parties are always encouraged to identify and discuss their issues with their counterparties because compromise negotiated solutions are by far the most common method of resolving disputes. And that is true both before and after arbitration or litigation has commenced. Litigation is expensive and time-consuming, as we all know, and so if you're able to negotiate a resolution that's acceptable in light of all factors, that's the preferred result. Mediation can be a very effective tool as well. The figures that you hear regarding success rates for mediation are usually in the range of 90%, largely because parties attending before a mediator have one thing in common, and that is that they want to resolve the matter and that they understand that a resolution will require some form of compromise. But for matters that can't be resolved by agreement, a lot of parties prefer arbitration over litigation because it tends to achieve a quicker result. Arbitration can involve a more significant and immediate cost because the parties also incur the cost of the arbitrator, whereas the fees for the services of the court are essentially negligible. But arbitration can result in a ruling within a matter of months as opposed to years, and the parties also generally have some control over the arbitrator that's appointed and can often select a subject matter expert that can move the matter forward and provide a ruling more efficiently. Litigation can be a long road, and that is enhanced all the more by the current restrictions on access to the courts. As it stands, until May 31st, which is a date that could be extended, it's been extended once from May 1st, courts are hearing only urgent and emergency applications. And so in general terms, this means that applications for relief that is not absolutely urgent, such as an injunction or a preservation order, will generally have to wait until the restrictions are lifted. Time-sensitive commercial matters where there is an immediate and significant financial consequence that may result if there is no judicial hearing are considered urgent as opposed to emergent. They qualify, the courts will certainly consider hearing them. They're second in line to emergency applications, but many insolvency matters will have a reasonable shot at being heard on this basis. The court is considering each case on a case-by-case basis, and the process requires a request to have the court hear the matter as an urgent or emergency application. Limitation periods and filing deadlines, except for with respect to commencing documents, statements of claim, and originating applications, have been extended, and ordinary lawsuits and applications are not currently being heard. So the ultimate result within the CAPL and in general is for a negotiated resolution of disputes, either with or without the assistance of a mediator. Where that is not achievable and parties are wishing for a more a quicker ruling on their dispute, they will prefer to arbitrate. There are arbitrators conducting arbitration via web platforms during the court shutdown. But for those who are prepared to wait or wish to litigate in the courts, they can file their claims now, but unless it's an urgent or emergency application, it won't advance until the courts reopen fully. but that can be a longer and less expensive mechanism to use for those who don't want to arbitrate.
Thanks, Clay. And we don't have any guidance yet, just following on your last point, on how the court is going to deal with the massive backlog of things that are getting filed that are not being heard. I'm sure we'll hear more about that in the future. Looking at the time, it's time to wrap up. So I just wanted to thank our panelists for presenting today and having this discussion. It's unfortunate we can't have a more interactive discussion with this many people on the but I do want to thank everybody who's attended. We hope you've found the presentation helpful and given you some food for thought. Again, if you have specific situations, please talk to your internal or external counsel before you do anything. There are some high stakes involved in some of these things that we've been talking about, and if anyone wants to contact any of us, our contact details are on the screen, and of course you can find us on the internet on our website. And with that, we will end the call, and thank you everybody very much.